Good afternoon and welcome back. And sir, you're reminded you're still under oath.
Yes, Your
Thank
Honor.
you. And Mr. Blair, continued cross.
Thank you.
We're back. Sorry, they
Mr.
came back
Trecker,
early.
I want to talk to you about formulating a hypothesis, if I can.
Okay.
There is some common sense that's used in this, correct?
I would hope so.
Because, I mean, hypothetically speaking, and this is very hypothetical, an alien spacecraft could shoot a laser beam into a house. That could be a hypothesis, correct?
Bingo.
It would be wrong, but it would be a hypothesis.
Fair, and that's what I'm trying to get at. There are some hypotheses that are just automatically discounted because they're very illogical, correct?
Yes.
And not likely to have happened, correct?
Correct.
So when we're talking about considering hypothesis, we're talking about what the investigator may consider to be a logical hypothesis, correct?
Correct.
Based on maybe the circumstances that they observe, correct?
Yes.
Sorry, no intro music. They just came back early, so we had to jump.
And is it fair to say that one investigator might look at the work of another investigator and maybe come up with different hypotheses? Is that correct?
That's correct. One of them would be wrong, if not both.
Well, and that's what I'm getting at is this is your work in this line of work, this fire investigator, it's subject to interpretation, correct?
To a point.
And so therefore, you may reach one conclusion on something and somebody else might reach a completely different conclusion, correct?
And as I said, if that's the case in something like this, either one is wrong or both are wrong.
And obviously you're not reaching any conclusion here today, correct?
My conclusions are that I, with the information I have, cannot make a conclusion other than undetermined.
Fair. You were asked questions about the red gas can, correct?
Yes.
And you at one time were a government investigator working for the city of Detroit, correct?
I was.
And you were trained to collect evidence, right?
Yes.
And if you had gone to a fire scene and seen a gas can out in the front yard, you would have collected it too, wouldn't you?
I believe I would have, yes.
So you take no fault in the fact that Mr. Leroy collected that gas can, do you?
No.
Because that's data, correct? Or possible data.
Possible, and that's why you do it. You know, then you do the analysis and all the other things, but yes, you'd collect it.
And you were asked questions about there being an ignition source in the living room. Do you recall those questions?
Yes.
And there in fact was an ignition source in the living room, was there not?
Yes.
It was the fireplace, correct?
Yes.
Because we know there was a fire going in the fireplace, correct?
Yes.
And those are based on the statements of Ms. Stermer, correct?
Yes.
Were you aware that we heard testimony about the boat that was used to move Mr. Stermer yesterday?
Heard testimony. I've heard different bits of testimony. I'm not sure what you're referring to, however.
Fair. Did you hear the testimony of Trevor Stermer?
Trevor Stermer. I didn't know. I was in the conference room. I wasn't allowed to be in here for that.
Would it surprise you to learn that it was a 6-foot plastic boat?
No.
Would it surprise you to learn that it never had a gasoline engine on it?
Never had what, sir?
Foundation.
I think it's an appropriate question of impeachment, Your Honor. He's been talking about it, and we learned testimony yesterday that there was no gasoline engine on it.
The objection foundation is misrepresenting the testimony. The jury can look at their notes.
I'm not sure he is, so I will overrule the objection.
Your question again was?
Sure. Would it surprise you to learn that there was never a gasoline engine on that boat?
I would have no way of knowing either way whether there wasn't or if there was.
And you've been doing fire investigations for about 52 years, is that right?
Let's see, 71, 29, 49, yes.
Yeah? All right. All right. And when you reach a conclusion in a fire case, okay, or a cause and origin determination, you're not making a legal conclusion, correct?
I know you've talked about legal, a couple other things. It would be my conclusion based on all the facts and evidence, and I would turn it over to a prosecutor or something, yes.
Very good. That's your opinion, correct?
If I say it, it's more than opinion. It's based on more than just opinion. Opinions anybody can have, and they're worthless sometimes. But no, if I say the fire is an arson, that fire is an arson. There is no opinion about it. It's the facts that are in evidence that prove that.
But someone could disagree with you on your conclusion, correct?
And one of us would be wrong.
Could be you.
This case, it wouldn't be me.
Well, it could be you, though, correct?
No, because I have the evidence to substantiate my position.
Well, I'm not asking about this case, and we were talking in
No, I'm not
generality.
talking about this case either.
Okay, all right.
I thought we were talking about generality.
Sorry.
Yes,
Okay,
if you
thank
wouldn't
you.
mind not cutting the witness off.
So you're saying your conclusions are always right?
No, I make a lot of mistakes. The main mistake I make is that when I have 95% that I think it's an arson, and I don't have that other 5%, I'm wrong because I call it undetermined, but that's the only proper thing to do.
You've been involved in criminal prosecutions before?
Many.
You've been involved in other fire criminal cases, even not as with the prosecution, correct?
Yes.
And there's been situations where you've determined a fire to be undetermined, but that did not stop a prosecution for arson, did it?
There was no case I've ever...
One more.
Oh, I'm sorry.
The objection is foundation?
Foundation, no, you go ahead and wait.
Yeah, I'll overrule that.
Okay. I've never been involved in a case where I said a fire was undetermined and it went to a court hearing, about, particularly in a criminal case. No.
You were retained as an expert in the People versus Clint Dunning, correct, sir?
I was.
And you determined that fire to be undetermined, correct?
I was trying to say more than that, but as a judge knows, I was ruled I couldn't say that, and there was no Daubert hearing or anything. But anyhow, it was an undetermined fire, yes, and I don't believe it was.
And yet, Mr. Dunning was still prosecuted and convicted of an arson-related fire. Isn't that correct, sir?
Objection, Your Honor.
This is
He
impeachment.
wasn't on the side of the prosecution. He's mixing apples and oranges here.
No, I'm not.
Yes, absolutely.
I'm going to allow the prosecution question, but not the conviction question. I don't see the relevance to what some other jury on another case did to argue.
Well, I guess what I'm trying to get at is, because that was a response directly to his question of he's never been involved in a case where he was made it undetermined and then the person got prosecuted. Well, I think...
So you can ask about prosecution, but not about what a jury did.
And if he limits it to where he was on the prosecution side, that's different than you're the defendant.
I'll allow you to ask about the prosecution question, but not
Fair,
what the
fair.
jury did. That's,
So the bottom line is, Mr. Dunning was still prosecuted, correct?
He was prosecuted without an adequate defense, and he will be tried again, or he will be exonerated sometime in the future.
And that's your opinion, correct?
That would be my opinion.
You're not a
I
lawyer,
can't-
correct, sir?
No, that would be my opinion. I can't say that that's going to happen. I believe it will, that's all. But you're right.
That is your subjective belief, correct?
That would be true.
No further questions.
Wow. It got spicy quick. I'm not sure what everyone had for lunch, but it had plenty of hot sauce on it.
These last couple of questions, sir, that you were asked, you were testifying for the defendant.
Yes,
You've never been involved in a case. You were in law enforcement for a long time, right?
yes,
And you've never been involved in a single case where you were the fire investigator, where you testified or had an opinion that it was undetermined, where there was ever a prosecution. Is that what you're telling us?
that's correct.
Because if there's no intentionally set fire, incendiary fire, there's no crime.
Objection, Your Honor. He can't. That's a legal opinion.
Yeah, that's argument. I'll sustain the objection.
Then you were asked questions about the gas can. You remember that? This
That's a
red
lot of
gas
questions,
can,
yes.
a lot of questions. And what you would have done, you don't fault Mr. Leroy for taking it, right?
Correct.
The next day, the day after the fire, right?
Yeah, it was a day later, but he said, I think on the stand, he didn't see it the first time, so
Would
you
you
wouldn't
have
take
done,
it if you didn't see it.
would you have done something more than he did? Would you have done something like check for fingerprints?
Probably not, because on those cans, it's almost impossible ever to get a fingerprint off those cans. They're not smooth.
Remember the questions you were asked about the scientific method, and could different experts look at things, same data, same evidence, and come up with different conclusions? You remember that?
Yes,
The point of the scientific method is that you have reliability and reproducibility, isn't it?
yes.
Okay. So if somebody does a thorough, proper investigation, another expert looks at it, like a peer review, what should be the outcome?
That peer review should confirm whatever the first person did.
If it's done properly,
And if you have all the, the information that the first person had, yes.
like collected the data, the evidence.
Right, if the data isn't collected that you don't determine to be of any value, somebody else can't look at it and see if it was or wasn't of any value.
So under the scientific method, if it's done properly, you should come to the same conclusions. You would only come to a different conclusion if what?
If you didn't have the same data that was preserved, even if two investigators came to the scene at the same time.
I'm just talking about just a situation like this where
yeah.
you don't get a chance.
They have
All
to
you have
wait
is
it.
what the person did before you.
Yes, I or no one else would have had a chance to have the same information and data that Special Sergeant Leroy would have had.
So if it's done improperly, you might not come to the same conclusion. You come to a different conclusion.
Improperly or inadequately.
Okay.
Back to that
Phil,
word.
I
That
love that
ties
you
in.
used
Let's talk about adequacy.
your 24-month message.
First
for
thing
this.
you were
Thank
asked.
you so much.
Had to do with the definition of an adequate excavation. Remember that?
Yes, yes.
Does adequate mean middle of the road?
No, I think adequate to me, and I didn't look it up in the dictionary, I would have if I had time or had a dictionary. I mean, it means enough. Adequate means enough.
You didn't have time
Whatever
to
that
look it
enough
up in
may
the
mean, it
dictionary.
means it's what you need.
It certainly doesn't mean average.
No.
Deer Park Waters made it back into the courtroom.
In your opinion, was there any excavation that Mr. Leroy did that could be deemed adequate by any standard in your field?
Well, if Mr. Leroy said he removed all the evidence, I saw that
Your Honor, I guess I'm going to object. I think he can give his opinion about what he believes, but not the entire field. I don't think he can speak for every cause and origin expert on the face of the earth.
You can
He's-
limit the question.
I'll limit the question. You're certified by AIAA,
yes,
the NAIA.
yes,
You've taught for years.
yes,
You trained for years.
yes.
Is there any, in your experience, any type of organization that would suggest that what Mr. Leroy did with his excavation was adequate?
Objection, Your Honor. He can't speak for every organization. He can speak for himself.
I'll sustain the
Okay?
objection.
In your opinion, sir,
This is asked and answered.
did Mr. Leroy do anything close to an adequate investigation?
Anything close is very vague. I would say that NFPA 921, there's a photograph and some things you need to do, particularly in a fatal fire, about sifting debris. There was a grid search when I don't
He's
know,
lost.
I got it marked, but ultimately, I think we talk about it depends, you know.
That's not the answer defense wanted. They wanted
Well,
a
let me ask
solid
you this,
no.
sir. He testified he cleared the floor, 18 by 18. You remember that?
Yes,
Did you see any evidence that he did that?
I saw a space of maybe, I can't really tell you dimensions, 4 by 6 toward the fireplace that was cleared, and I saw other debris outside. But going back to my layered talk, because we have collapse of roof and flooring and everything, you'd have to get down to the floor, but he said he did it to the floor.
Did you see evidence that he cleared an 18-foot by 18-foot by 2-foot area of rubble, sir?
I did not.
Did you see any evidence of a 7-foot pile of rubble, 4 feet by 8 feet by 7 feet, that he said he did?
The cubic foot thing, how much we had for 18 by 18 by 2 or 3, if it comes to that, a 7-foot pile, no, I didn't see anything like that.
Now, you were
Debbie,
asked a lot of
thank you so
questions
much.
about
25
area of
minutes.
origin and the size of origin. NFPA 921 guides us on that, doesn't it?
Yes,
Ideally, you'd like to find a point of origin, am I right?
that's the goal.
And what happens as you get larger and larger and larger areas of origin? What happens to the reliability of your opinions?
The larger it is, and you can't confine it to something smaller, how can you actually say what occurred if you have that big of an area of origin? To say this is what the origin was and this was the cause.
I want to go back to Mr. Shinsky's photograph when you talked about, let's see if I can get this now. Mr. Shinsky's, oh, that's what it is. Photograph regarding the back of the house. Thank you, Ms. Heidi. I think that's it.
Trying to connect his iPad back to the court camera system through the Apple TV.
Okay. Getting back
Using TrialPad for iPad, the app.
to Mr. Shinsky's photograph of the house, you were given a lot of questions about the chimney chase, remember?
Yes,
Based on your review of the records, drawings, everything, how high was that chimney chase?
it would have to be higher than the peak of what was covering that, those 2, 4, 6, 8 bay windows.
Okay. And these bay windows in the back of the house, what can you tell us about what would have happened to them if there was a fire in the living room?
If the fire was in the living room and originated in the living room, the fire takes the path of least resistance. It doesn't seek or look for or anything like that. It's an inanimate object, but it will take the path of least resistance. And with that in mind, those windows are going to be compromised and the flames are going to come out where that oxygen is coming in. And if it started there, all of that should be burned away. That shouldn't be standing there anymore.
Because fire goes up?
Yes.
Another grunt.
And also, if we're talking about, you said there was OSB board, the testimony has been a lot of wood, open wood in the house, and around the chimney chase, OSB board.
Yes.
If that is up there, and we're talking about 2 stories, how is it going to fall into the living room?
Well, again, where it actually started, which none of us know, where that fault, if that's what the cause was, we don't know the level of that height where it
None of
was.
us know.
But if it was still in the confines of the cathedral ceiling, it would fall inside the living room. If it was above that, it's going to fail and fall on the roof, basically, and cause a fire up there.
And you're not here to tell this jury definitively, based on everything you could find, that the chimney chase is the area of origin, are you?
Correct. No, I'm not saying that's what happened. I'm saying that was a very strong possibility, but I could not say it was.
And it's a strong possibility that has to be ruled out by the fire investigator?
Yes.
And did he?
No. Well, he ruled it out, but he didn't have evidence to rule it out.
Okay.
Okay.
All right. So,
Not the strong finish defense
under
wanted
the
there.
scientific method, what you folks always use, you have to rule out these alternate probabilities, possibilities, right?
Right. You have to be able to disprove everything else except your final hypotheses.
Right. Now, let me ask you about possibilities. Since Mr. Blair asked you about, is it possible somebody could pour gas on somebody in the living room and then run down the stairs? You remember that?
I do.
experts, do you deal in possibilities?
No, that's so much of guesswork that it doesn't apply to anything as far as science goes.
You deal in evidence and probabilities?
Probabilities, yes.
Okay. Then you were also asked, well, why didn't you use a human being for those sweatpant tests, or an animal? You remember that?
I do.
And why didn't you use a human being for a sweatpants test, or an animal like a pig or whatever else he said?
There's this anthropologist doctor in California, and I wanted to set up, because she burns bodies and for a variety of reasons, but she's an anthropologist, so she burns them too much. And I wanted her to do an experiment for
She
this.
overcooks the bodies.
And she would, but she was already tied up to doing all these burns for an anthropologist, like bones. They were down to nothing. So I tried to get a cadaver somewhere else. All those things failed, so I couldn't do that. But the mere fact that I know what's going to happen to a body when you pour gasoline on anything.
Objection, Your Honor. He's testifying to things this court's already ruled he
Yeah,
cannot
Your
testify
Honor,
to.
please, there's a legal objection in here somewhere.
It's irrelevant.
There.
It's outside the scope of
I'll
his
sustain the
expertise.
objection on
Thank you.
relevance.
Why didn't you use a live body like Mr. Blair suggested?
Hint, hint.
The live body would have gotten hurt or killed.
And it's unethical?
That would be a good reason, yeah.
That wasn't my first reason. But
Oh,
I
you were
don't
also
think Mr.
asked
Blair
about some
suggested a live
questions
body.
about polyester and difference in polyester. First of all, you understand, you do understand polyester is a man-made synthetic
It is,
plastic,
yes.
so it doesn't matter what kind of little blend of polyester it is.
Correct.
Polyester melts.
Yes,
And that's what you're trying to illustrate in that video?
yes.
Okay. Give me 1 second, Your Honor. I think I might be finished. You're aware that Mr. Shinsky has a lot of expertise in fire investigation, origin, and cause,
Yes,
as do you.
yes.
Are you aware of any expert in this case, other than Mr. Leroy, who said that what Mr. Leroy did was adequate?
I'm going to object, Your Honor. That's going for hearsay.
If he's aware, I didn't ask for a statement.
I don't understand the question, honestly. What
Are
is
you
it?
aware of any evidence that any expert in this case besides Mr. Leroy defended what Mr. Leroy did?
I'm not aware of any evidence.
What was your answer?
I'm not aware of any evidence to that.
Okay.
All right. Thank you.
Thank you. Mr. Blair?
did that open a door?
You would agree with me, sir, that cause and origin investigation is not a, like, quote-unquote, hard science. Would you agree with me there?
What do you mean by hard?
Well, that's a bad question. Let me rephrase that. Like, for instance, a chemist in a lab or a DNA expert working in a forensics lab that rely on very controlled environments, scientific instruments, etc.
Yes,
So you would agree with me that that cause and origin is not a hard science?
there are variables that are uncontrollable, yes.
Because a lot of this relies on your training and experience, correct?
Correct.
And it's your interpretation of fire patterns, is that correct?
Fire patterns are being more and more discounted unless you have them covered with gasoline or some accelerant well, it depends what patterns you're talking about. I misspoke.
That's okay, that's all right. I'm asking in very general sense. It's you looking at something and then evaluating it based on your training and experience, correct?
Correct.
It's not something that you bring out a special instrument and it measures it and it gives you a answer within a reasonable degree of scientific certainty, correct?
No, we don't have that yet.
All right.
I'm the best thing you got so far. I'm never wrong.
Would you agree with me that a person that would have the opportunity to go to the scene and view the scene in its original condition would have kind of a better idea of what went on?
I guess I have to use,
Objection foundation and call from the speculator, we're talking about would have a better opportunity than you want.
He's an expert.
Overrule the objection.
it depends is what I was going to say, and then I will explain it depends. It depends on the level of experience of the one person as opposed to another, and it more depends on the first person preserving the evidence for someone else to see.
You would agree that being able to view something with your eyes in person is better than looking at photographs, correct?
Absolutely, but that can't be done in fire investigations because you're moving debris and changing the aspects of the scene as a way to get to the cause of the fire, and that's why you have to document it.
And just one final question, and just so we have a foundation here, you again reviewed Linda Stermer's statements, correct?
During the course of my 12 years involved in this, yes.
And you reviewed her statement that she stated that the only place she saw fire was between Todd's recliner and the master bedroom, correct?
I guess the word between again means it wasn't on either one of those things, it was between them, but if you want to say the expanse of the fire, yes.
In other words, she observed a trail of fire between the master bedroom and the living room and the recliner, correct?
I believe I answered that a long time ago, saying a trail is a whole different subject and a whole different observance or perception of a fire that is burning in all of those locations. There's nothing to do with the trail.
Nothing further, Your Honor.
Thank you.
Oh, I'm sorry, hold on, Your Honor.
Mr. Mueller, briefly.
Two or three more questions. Person of your experience, person of Mr. Shinsky's experience, even Mr. Leroy's experience, very hard to fool somebody like you into thinking that an intentional fire is an accidental fire, right?
Objection, Your Honor, from the question.
I'll sustain it.
There are obvious signs when I apologize.
It's sustained.
Thank you. There are obvious signs when somebody is trying to intentionally start a fire, right?
Objection, Your Honor, calls for, well, it's a very broad answer, it calls for speculation.
He's got 50 years.
The way it's phrased, I'll sustain on speculation.
Okay. Can you tell us the kind of, you mentioned trailers. Explain for the judge what a trailer is.
A trailer
for the jury.
Yes, observing a trailer. There was more of that years ago than there are now, but people would pour gasoline. I think that Mr. Blair actually said, you know, if you walked in this room and somebody poured a trail and set it on fire, you would very clearly see it visually if the fire flashed and went out. I think I remember Mr. Leroy was asked about a flash fire before too. And it's very obvious to see, and you'll smell the gasoline and you'll see this pattern. But it doesn't conform to the question I was asked and what Ms. Stermer saw.
So years ago, people used to do this, but they don't now?
Would be obvious as opposed to that there was gas within a boundary.
Well, trailer can also...
I mean, strike that, not gas. Fire within a boundary versus a trailer.
Right, exactly. And a trailer is a whole different meaning by me in all the years and way before 921. It clearly shows whether it was more masked by a flashover or whatever the case may be. The whole room may be involved, but hypothetically and sometimes often, when you go through the debris, you'll find this pattern, which is called a trailer. But the question I've been asking is not anything to do with a trail or a trailer.
There were no evidence of a trailer in this case, was there?
No.
No evidence of multiple points of origin in this case?
No.
Which is another sign
Yes.
that might suggest arson?
Yes, if a fire was over here in this corner and a fire over in that corner with no reason for either one of them to happen, and they weren't communicated one to another, it'd be clear to all of us that that was something wrong.
Okay. And then finally, your ability to determine whether somebody did a job properly is based, one, on, you said, their competence and experience,
Yes.
and also would it be based on their candor and truthfulness in what they did?
Yes, I always liken fire investigation to a chef. You're only as good as your last meal. Wolfgang Puck may have made a million good meals, and, as Mr. Leroy, but this case wasn't sufficient, wasn't done sufficiently.
More water.
I don't have anything else. Thank you.
Question about Wolf.
Obviously, in this case, we can't verify any trailer or anything in the living room because it was completely destroyed, correct?
The floor was, yeah, it was OSB. It went down below. Whatever was below, you might find the remnants of a ignitable liquid, but you wouldn't find the trailer. Correct.
Well, there is certain factors that can determine whether or not you're going to find an ignitable liquid, correct?
Yeah, it depends on the degree of damage.
Right. So if the floor was completely destroyed and burned away, that could be a factor, correct?
Well, when you say it was completely burned away, there's residual debris on the floor. Yes, a lot of it was consumed and fell. The condition of how much was left is something I'll never know.
And another factor that could affect gasoline would actually be the amount of water used by a fire department, correct?
Gasoline is not water soluble. I've had cases where, I've actually did demonstrations where I could put 1,000 gallons of water on 3 ounces of gasoline on the ground, and the gasoline would stay on top, just like when you have oil slicks or slicks like that with petroleum distillate. They're going to remain there, and the water's going to go past it. It could push it around, but it's not going to change its components.
Well, that's my point. What you just described sounds like a controlled experiment where it was on a standing body of water, correct?
No, I'm saying that I poured the gasoline, and I found gasoline when 500,000 gallons of water had been applied to a fire scene, and still found residue of gasoline that was analyzed in the laboratory. What I'm saying my demonstration is that I poured a minuscule amount of gasoline on the ground and then didn't direct stream that thing so it would be spread around. It was not lightly put on. It was a fog spray. It wasn't fog, but it's wide little pellets like when you're in your shower. And then we let it sit for a while and wet and still get the gasoline. But I'm saying in the real world, I've done that also. You know, we know sometimes that there had to be something to accelerate a fire based on witness information, based on what we could see physically. And we have come up with a gasoline sample after going through all the debris.
Sometimes you don't, correct?
Sometimes you don't, correct.
And you would agree with me, obviously, that a fire hose is different pressure and different volume of water than that of your hose you use in your experiment, correct?
No, I used fire hose.
Oh, you used a fire hose.
First off, I had a fire truck of my own, but that was done, I believe, in Detroit. We did it with a bigger truck. I had a mini pumper.
That was not in a burned out house, correct?
No, but I have had the same experiences in a burned out house. And by the way, I can tell you the pressure, if you want to let me. It's usually 200 pounds per square inch is what we fight fires with. Can vary a little bit here and there, but it's a lot of pressure.
Thank you.
Yeah, just finally, whether you can find any remnants of gasoline depends on how good you do your excavation and how thorough it is.
Certainly we'd be part of it.
Okay. And any evidence you have of evidence samples for gasoline that Mr. Leroy took, there was no evidence of gasoline, right?
We didn't take any sample.
Okay. Thank you.
Jury, do you have questions of this witness?
Okay, I see some coming in.
Everybody's hands go up and they stay there. Yeah, jury questions coming in hot to this fire expert who was, I would say it's safe to say he's bungled the big finish, right? He flubbed it. It was a soft pitch question with an easy answer home run, and he turned it into something it wasn't, and basically had to resort in the defense almost leading him and saying the answer for him before he would say it. So it was tough. It was tough. Now, I was setting up Top Mark Media when I heard this testimony was coming in. Did he say he's actually working for free? That he's not charging anything and that he won't be billing anything to the defense in this case? That's awesome. That's cool. That is rare. Last time we saw an expert that did that was a really good one. It was Dr. Joe down in Florida with a Maya trial. Said they're all working. Everyone's working for free in this case. No one's getting paid. Is that because the prize money goes to the victor? No, just kidding. Sorry. Too soon. State's Cross was just one burn after another. At one point, the state even busted up laughing, like visibly on screen. Like, say, no further questions. That is just so ridiculous that the jury can tell that it's not worth believing. All right. Koberger hearing is now approaching its third hour. It's been going for a while. I've had a break in there, but it's still going. That's still over on Top Mark Media if you want to go back and watch that on a replay. There were some good parts, especially at the beginning. Haven't listened to the last little bit, but
About the videos, he can talk about moments in time where he made certain identifications and why he said what he said.
yep, his lawyer's still making argument. Talking about a video right now, so I'll have to go back and catch this part later. All right, third hour. Holy smoke! Yeah, we're not quite there. My live stream shows 3 hours and 3 minutes, but we started maybe 5 or 10 minutes before it began. So, all right, 2,000 hours worth of work and not being paid a penny.
Somebody just sent me a video of roaches fighting. I don't know who won.
They even asked if they'd be getting any money later from anything. I'm guessing from a book or a movie. The judge, is it Hibbler? I can't remember his name. I think it starts with an H. And Koberger is an amazing judge. I love that he rules from the bench. A couple things he said he's going to take under advisement, but he's making rulings as he goes along in that case, and it's great. I love it. What happened in the Lori Vallow trial? It is still going on, and it is not so. I mean, like, just to give you a little glimpse into that one. Today, Lori Vallow made a motion to the judge to strike and throw out all of yesterday's testimony because it violated her constitutional rights. And the judge is like, okay, I might need a little argument from you on that one before I go ahead and rule in favor or against, as the case may be. And Lori's like, I don't want to talk about it. I don't want to argue about it, Judge. Just do it. Yeah, it's out there. I mean, I think the people watching that are going to get really frustrated before that case is over. Jamie, you're gonna have to watch it on your own. There's just too many trials to follow. We're invested in this one, and then we've got the Karen Reed trial coming up, which I'm also invested in. There's just too much. We've got Koberger over on Top Mark Media. There's a lot going on. Yes, I'm serious. That's happened. That happened. All right, still more questions. I don't know why the judge is shielding her face like she's giving out baseball signs or something. I guess that's so the jury can't read lips. Is this the last defense witness? No, this is the second defense witness, right? The first one we had was the friend of the defendant who got up and testified the exact opposite of pretty much everything else we've heard in trial. That she basically lived in the house with them and her kids lived there and she was there all the time and there were no fire extinguishers and the walls were open and bare and nothing was covered and just everything opposite from what we've heard from the people who lived in the house, like the sons. It was a little different. It was a little different. But they needed that first so that the defense here could say to the fire investigator, there's testimony that. And it came from this lady. And it was a little out there. It definitely means you have to pick and choose which witness you want to believe as a juror. Because now that she's testified, we can't both be right? One of us will have to be wrong. Will Linda testify? I don't think she will. I don't think it would help her at all. Are you one of those people saying frustrated for frustrated? No. It is a made-up word. Flustered and frustrated. Ne'er shall the twain meet. Two different words. Flustered is think more like me anytime I'm trying to think up an analogy. I'd be flustered. I'd be like, something like, what is it? That would be flustered. Frustrated would be like, oh, they just don't get it. There's a difference. Carter says, I could tell yesterday's skit was a skit, but I wanted it to be real so bad. Carter, we could recreate that video with actual excerpts from actual Zoom trials that we've watched. It's so real. It's so real. Missy says, finally, I have 2 streams open waiting for a verdict. Chris from Trial TV Live and RA. I think my coworkers think I might be insane. Awesome. Chris is awesome. Love what Trial TV is doing. Trial TV Live is covering the Lori Vallow case, and they're covering it. They're covering the whole thing. That's where we portaled over to on the first day when we bailed right before court was over. What the heck? I come back to a grunting poll. Yes, I forgot. I've got a poll up right now. Thanks for the reminder, Red. Should we make a exclamation point grunt sound effect? It would basically be, this is what I envision. I would go through, or I would have one of my fantastic mods go through and give me the timestamps of all these grunts that we get from the defense. And we would get several samples, like audio samples, like someone would be like, or and we would get all the grunts, and we put them together, and I would load them up in a file so that anytime you typed exclamation point grunt, it would make that sound a lot like some of the other sound effects that work on, on our channel. So the poll is, I'm going to close it right here. It says, should we make a grunt sound effect? The winner is yes, but we need 12 sample grunts. Yes, but we slow it, slow it down 25% speed. Is tied right, actually just behind. No, I do all my own grunting. And the smallest one was yes, but only
from the jury, sir. Are NFPA guidelines interpreted subjectively or absolutely?
Well, as I said, NFP guidelines total? I'm sorry.
It just says, are NFPA guidelines interpreted subjectively or absolutely?
Depends. Some are absolute and some, are, they can't be used as a standard or a, doctrine of how you do things. But
so it depends.
I think they're probably referring to 921, though, don't you think, or not? Does it say?
Yeah, it just says NFPA guidelines. My guess is the 921.
Yeah. So, no, 921 is a guide, but it is a guide that is supposed to be a subjective, not a subjective, an objective document that you take, because it talks about don't be subjective in a lot of the areas. I think some we put on the screen. So, but it's not an absolute, it's not something you must do, but if you don't follow it, I can tell you that it won't be good for you in the end.
If you could answer this one with a yes or no, please.
Okay.
Do you have any personal connection with Linda Stermer or her family?
I do not.
Whoa.
Do you conduct all investigations remotely? If not, why?
Almost never remotely. I'm almost always at the scene conducting an investigation like Mr. Leroy does.
Why?
Not too many other ways of doing it other than if you're going to be trying to assess somebody else's work.
Where was the electrical panel installed in the house?
Basement level along the south wall.
Oh, the jury thinks
According
she
to
flipped the
NFPA 921 regarding excavation and debris examination, the terms adequate in quotes, and some, in quotes, were shown. Does the investigator determine what these terms include?
I'm not sure about the word some. I'd have to, see that paper again. But there's a lot of, an investigator is given some latitude about what he feels is necessary. But if you're going to make a definitive cause determination, you have to go above and beyond that adequate level to make sure that your determination is correct.
Thank you. In Leroy's photo of the rear of the house that you reviewed, more of the exterior is burned away on the north side of the bay window than the south side. If the fire started in the chimney chase, why would you get an asymmetrical burn pattern on the window area?
There's only one picture, I think, that was shown. I don't know in Mr. Leroy's, I don't think he showed any other ones. But the dash cam from the sheriff's department, first arriving sheriff, you can see that the wind was coming out of the southwest, going across the house to the northeast. That's the explanation. Well, ventilation and fire suppression also.
How
There's no
common
fire
is
suppression
it for
at that
you to
point.
be called to review a case done by someone who was an expert in their field?
Common's kind of a common word. I guess if I took percentages of how many fires I do and do somebody else's, do a technical review as opposed to my own, it would be slight.
Having not been to the house yourself right after the fire, did you at any point talk with Mr. Leroy to review any part of his investigation, to ask why or how he came to any conclusions? If not, why not?
Okay, I relied on his report and other information that he gathered. Normally speaking, we don't communicate, although we had the federal evidentiary hearing, we may have spoken a little bit, but it really wouldn't have been getting into the meat of the matter of the fire. It would be what he reported and what he testified to and what I testified to.
You stated there are 2 editions of NFPA 921, one published in 1992 and one in 2024. Are there procedures and codes in the 2024 edition that are not in the 1992 edition?
I wish I'd have brought both of them in. They're in my car. The 921
What you looking for?
today is this thick. The 921 in 1992 was 1/5 of the dimension of this book. But I didn't mean to confuse you. These are not the only 2. They're published and printed almost every 3 years. The first one in 92, then there was one in 95, 98, 2001, 2005, then 2008, then 2011, 2014, 17, 21, and then this book. Each one of them, became more refined, had more information for us to have a better knowledge base. A lot of the book really doesn't have a direct relationship to what Mr. Leroy and I do, but it's something we should know about and how to proceed from there. More about electrical and mechanical, and they've added more about wildland fires, seaboard vessels, big, not just a boat, but watercraft, I guess, put it that way.
Okay, so there are some differences?
Yes.
Okay.
Yes.
And which edition are you quoting from today in regards to fire investigation, procedure, and regulations?
Everything is from the 2024 version because it's not a standard. If it was a standard or a code, you would rely on the code or standard of that moment. But this is never, by the volume, you can see it's ever changing or ever more additions. And today I need to be testifying to what was in 2024.
Is the 2024 edition of the NFP 921 relevant to analyze information, data collection, and excavation from 2007?
Yes, it expands upon it, and what was done in 2007 might not have all of the different things that need to be done now, but we are now in time frame, and if I may have testified to less than this book naturally because there wasn't this big book in 2007, but I would be responsible for what happened in the interim, how much more knowledge we have. Our knowledge base is greater, so I would have to testify to what we have now, even critiquing my own investigation from 2007.
If you believe the fire may have started in the fireplace chase, then how do you explain how the fire made it to the victim recliner in the manner depicted by defendant?
Oh, it was at this moment she knew she screwed up.
If the chase is compromised and there was no barrier between the chase and the living room, there could have been a great deal of falling debris coming down on top of him. His hands were burned like this, as though he was stopping himself from whatever was happening.
He can't testify to the position of the...
I'll sustain as to the position of him. We'll move on to the next question. How do you explain the victim burns on body but sweatpants seem unharmed?
Okay, that's a pretty easy one for me, but your body can only take temperatures from 110 degrees Fahrenheit and up. Pants, clothing items, I don't know if any of you have heard of them. There's two movies, one remake, Fahrenheit 451. That is the
about burning books.
Basic lowest temperature that combustible clothing materials and other materials
Paper,
will actually ignite. So well, I can't get into that. That's the reason. Is he's not burned. I mean, the pants aren't burned. He's burned because he could only take the 110, and he could only take it for a short time. I would say that because of convected and radiated heat transfer, I'll give you another example. The sun is radiated heat. If we stay too long in the sun, our clothes won't burn, but we will. We're going to feel that heat, especially when it's exposed, but even if it's protected by the clothing. But that was one of the big reasons why
his hair
there was no way.
off.
Well, can't get into that.
Okay.
That we can leave it at that. Skin and body burn much quicker or get degraded because of a lower temperature exposure.
Thank you. Counsel, any questions in light of the jury questions and answers, Mr. Blair or Mr. Mueller?
Yes, thank you.
Human hair burns at 230 degrees. All his hair had burned off. Linda reported he came out of the house and he was on fire.
I'm going to go backwards because it's freshest in my mind. This
On
idea of
fire.
skin burning, but the clothes didn't burn. Does NFPA 921 speak to that?
They do, or it does.
Do you have a section on that you can tell us about?
Not sure if I have that section marked anymore. I might have taken it out, but I'll find it.
How about section 24.2.5? And 24.2.5.1. How about we go there?
Okay. I do need glasses, I think.
You want my pair?
I got it. I was just looking, and a 7 looked like a
Here, use my glasses.
5 or something to me. But yeah, it's on the top of the page.
Little product placement there, little NFPA 921. You can buy your own copy for $146 on Amazon.
Yes. I got it.
24.2.5.
Link in description.
24.2.5, yes.
All right, what does that tell us skin burns at? Thermal burns begin.
Wasn't the section I thought it was going to, but let me see.
Are you saying you made a mistake?
Maybe I need better light.
I'd be able to answer this question, Your Honor, if we could just make it a little brighter in the courtroom. Because I can't see what I want to see here in this book.
This
That
talks
section,
about,
does that section, do we have a section that tells us thermal burns begin at 110 degrees?
we do, but I don't see it here. This is more about kilowatts and.
I might have the wrong section, but you do know what NFPA 921 talks about
It's
skin burns?
it's in the book. It should be in this section, I think.
Do you remember what Dr. Markey said the burns, how he described the burns as thermal burns?
Yes.
Okay. And then does NFPA 921 also tell us that heat can be transferred through clothing, causing burns to the underlying skin without any readily identifiable damage to the clothing?
Yes. Why, I've seen that firsthand many times.
And why is that?
Because of the ignition temperature, the temperature of burning for the clothing materials at 450 degree level, as opposed to your skin at 110 and a small amount above.
There's a picture that's up on the screen. I think it was addressing a question about some damage more to the north side of these bay windows, which would be the left,
Yes.
right? And then you mentioned a photograph from the in-car video.
Yes.
Does that show the wind blowing toward the north?
Yes.
Okay. Would that help account for the fact that you may have more damage to the north side?
Absolutely.
And with regard to one, you said NFPA 921 changes about every 3 years.
Yes, it's supposed to be consistent every 3 years. I can tell you that I was on technical committees, and I'm not on now. I get no more time, but hopefully I have a lot more time. I didn't mean it that way. Once this goes into print and comes out, the technical committees are already working on anything else that's new and advanced. And then there's the technical committee, like the judge, takes these things and looks at them, and then if they're valid, or I would say any of your questions are invalid, but questions that really make an impact for a newer section in the book or even a sentence, that will be put in, and then it's voted on by all any NFPA members at the end.
Mr. Trinkle, some questions addressed 2007's version and what might have been in effect then versus 2024. We are here in a 2025 trial. You as an expert, and any expert has to be open to change, right?
Absolutely.
So what standard or what guidelines NFPA 921 apply to this trial and this criminal case in 2025?
It would be the 2024 edition.
But you can't hold him to the excavation and
just
analysis.
with respect to the various guides, if you're not open to change, what is that evidence of?
Can't be stagnant. You always got to be moving forward and learning every day. I learn something every day. Sometimes it's irrelevant, but like stepping on a Lego coming out of my bed.
Oh, I have a question.
Yes.
Bingo.
There was a question regarding are some of the guidelines absolute or subjective? You remember that?
Yes.
The scientific method has been in effect since 1992 and before.
Yes.
Right? That has to be complied with.
Well, the caveat is it has to be utilized and complied with unless you can absolutely say you did something equivalent and it comes out to the same thing, just trying to get to what caused the fire. But normally speaking, if you said you didn't do this, they wouldn't even allow you to testify in most courts.
Certainly, Mr. Leroy was subject to scientific method in 2007, just as he is today, just as you are.
Yes.
And you have an opinion, you said, as to whether he complied or not with the scientific method, and that was?
No.
Okay. And the excavation principles in NFPA 921 are the same now as they were back way before 2007, right?
Yes.
So the fact that he didn't do what he told the jury he did, that would be in effect, you're held to those same standards.
Yes, you are.
Okay.
Can I just take a minute and say Samantha is an amazing mod? Thank you, Samantha. The others are as well, but just wanted to call out Samantha. She's amazing. Thank you so much.
So many questions. Okay. I don't have any other questions. Thank you, Mr. Trinkle. Let me get him his.
Yes. Thank you.
We're not done yet. We're not done. Get him, Tiger.
You, I think you've even testified that to this here in court today. You don't agree with all portions of NFPA 921, correct?
Some I get revised, and people like Mr. Leroy and myself would look at them and ask, or put a suggestion in, like the jury box, to make a change. I've had
The jury makes
sometimes
suggestions.
where the computer section was new, and the second edition that came out, I think it's 2005 and 2008, one of them said this is, and it was wrong. It was, a typo, but a big typo. And so then they put it now is not, but they left them both in.
Well, but I think you've even testified this here in court. You don't agree with some of the information or the way they define things in NFPA 921, correct?
I guess define, you have to explain what definitions you're talking about.
I think we talked about you used ignitable liquid.
Oh, yes, I don't like that, yes.
You don't like that, correct?
I do not, because I have to explain to a jury that liquid doesn't ignite. It takes me more time to get to the point of fact.
And NFPA 921 is not an absolute, correct?
Correct.
There's no requirement that you follow it, correct?
Requirements.
Legal requirement.
Was a good sign.
I guess there is no legal requirement.
And I think you testified to this in 2007, there were less requirements or less guidance, I think, in the 2007 edition than there was in the current editions of NFPA.
Yes, the 2007 would be somewhere halfway between these two. Each volume from the 92 version, which was very thin, the 2007 version increased in size and what was covered. And as I say, every year every edition, I've never seen it get smaller.
So I guess at the time in 2007, a fire investigator would have only had the guidance that the 2007 edition would have been providing, correct?
That guidance from the book, yes.
And would have only had then that guidance when conducting their investigation, writing their reports, so on and so forth, correct?
Right. We don't carry the book with us.
Because you would agree with me that looking back at something from today's standards to 2007, that's kind of reviewing something in hindsight, correct?
Yes, well, like I said, I would review my own now and probably criticize in a critique of what I didn't do the times before, but it wouldn't be critical.
But you wouldn't have been wrong.
But at the time, it may have been completely appropriate.
Completely appropriate. I'd have to know what you're talking about.
Well, sure.
A particular thing.
Well, you were just talking about looking back and even second guessing yourself or reviewing yourself, right?
Sure.
So, but what I'm getting at then is, if you're looking back and finding things you may have done wrong in, 15 years ago, it didn't make them wrong at the time, correct?
It all depends what you did wrong. If you called a fire something that you couldn't prove, and now you find out that you can prove it or disprove it, as you mentioned before, yeah, those are variables I can't really address.
Now, when a fire goes up, it actually hits a roof and spreads out, does it not?
It hits, let's take this room for example. Yes, fire starts on the floor level, continues to burn upward and outward, depending on the configuration of the room, configuration of the fire load, but eventually it hits a barrier like a horizontal surface, then it spreads out.
So, for instance, in the pictures we've looked at then, I think this is based on one of the juror questions, if the fire had gone up, it should have hit the roof and then spread to all areas of the roof in the Stermer residence, correct?
Way beyond what is the questions from the jury.
I think that's right in line with the juror question.
Oh, I'll let you ask, but I'll alert both of you. This witness has been on the stand since yesterday, so if you have any great questions, I'd suggest that you ask them now.
I think that's right in line, I'm sorry.
Thank you.
Could you please rephrase? I don't want to
Sure.
say something wrong.
If the fire had gone straight up and hit the roof and then spread out, like you've talked about what they do, it should have spread to all areas of the roof in the Stermer house, correct?
I don't think it's going to hit the roof. It's going to hit the ceiling of the cathedral ceiling, which isn't the roof. It's not right there. You've got probably scissor trusses or something to separate the ceiling of the cathedral ceiling from the roof, and it's going to spread from there first, and it's going to, as I said, heat and smoke, fire, rise, but they rise in a conical shape. It's not like this is three-dimensional stuff. Wherever the fire starts, say where Mr. Leroy is sitting, it's going to go in all directions around him and up until it meets that resistance, but that resistance is part of the house, not the roof.
Just a moment, Your Honor.
Okay. What if the state got it wrong?
I think you limited to great questions.
Yeah, brief, great questions.
You were just asking questions about complying, excavation, documentation. Those were absolutely required in 2007, just as they are now, right?
That's correct.
Please quit banging
And
the
that is
microphone,
ingrained in fire experts from the time they start training, right?
Yes.
You remember you were asked questions about, I'm going to call it, I forgot what Mr. Blair called it, playing devil's advocate with yourself. How could I be wrong?
Yes.
Right, and that's something that every fire investigator should do throughout their investigation.
Yes.
Do you have any evidence that Mr. Leroy played devil's advocate with himself on any part of his
Your Honor, that
report?
calls for speculation.
Do you have
Sustained
evidence?
speculation.
Okay. Is there a requirement in 921, back in 2007 and now, to be truthful and candid in your documents and reporting?
I'm going to object, Your Honor. I think that exceeds the scope of these jury questions.
Sustained cumulative.
Okay. Then I don't have any other questions. Thank you.
So you didn't really have any good questions.
Dialogue.
You can ask all the questions you want, jury.
May this witness be excused from subpoena if he's under one,
No
counsel?
objection.
Yes, I don't think he's under.
Okay. Thank you, sir. You're all done.
Sir, you may pack your bags and go. Let me say this. What if the state got it wrong? In what happened? What if there was no
You want me to
gasoline
take
poured on
this
top?
Trash to discard?
Yes.
I can do that.
I'm going to find out where
Oh, is this the gray the sweatpants
Yes.
that have been admitted?
That's an exhibit.
Oh, okay. What, was that admitted?
It's basically like a charitable donation.
That's my binder.
Was that admitted? No.
No, this is my,
Okay.
I just referred into
Okay. So, Mr. Mueller and Mr. Kelly, any other witnesses? Any other witnesses?
Yes.
Okay. You may call your next witness.
Haven't heard from Mr. Kelly. Who's up next? Do tell us who it is. We're all ears.
Sir, you can come forward. If you pause briefly.
the
Do you
fire
solemnly
guys
swear or
interpreting?
affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat.
All the defense whiteboards have coffee stains on the edge. I don't know what happened, but somebody spilled.
Once you're settled in, we'll have you tell
Look
us your
for it.
full name and
You'll see
spell
it.
the last, please.
My name is Mariusz Ziejewski, Ziejewski.
Good luck, Josh.
Thank you. Mr. Mueller?
Thank you. Sir, can you tell us what you do for a profession?
I'm a university professor at North Dakota State University.
And what is your specialty, or what do you specialize in?
My specialty is impact biomechanics.
What is that?
Well, that's application of physics, engineering principles in the study of forces on human body and effect of those forces on human body.
Okay. Can you give us an idea of the education you have that brings you to court today?
Well, my highest scientific academic degree is PhD, doctorate degree in engineering from North Dakota State University. I graduated in 1985. I have 2 Bachelor of Science degrees and 1 master's degree. All those degrees are from my native country, Poland.
4 degrees.
One of my Bachelors of Science degrees are in mechanical engineering, and I'm diplomat engineer from Europe. It has equivalent standing to PE, professional engineer's license in this country. My Master of Science is in bioengineering, or equivalent to bioengineering. My other BS degree is in life sciences. Then I became university professor in Poland and worked on my doctorate degree in Poland. And I was invited on a research exchange program between professors from Poland and United States. And back in 1980, I came to North Dakota State University. I quit my doctorate degree in Poland and started at North Dakota State as a part of my research exchange program, and graduated in 1985, became for 1 year lecturer, assistant professor, associate professor, tenure associate, full professor, and now I am professor emeritus.
Does that mean you're semi-retired?
Not really. I mean, I could, but no. But really means that it's a title. We can essentially do what we want to do. My choice is to continue work on the research. I have 2 PhD students. I don't teach.
What kind of research do you do, and how would it relate to injury causation that you're here for?
My research is in human brain modeling, mathematical modeling of human brain. In other words, how external forces affect human brain. I've been working on this project for the last 30 years. The primary sponsor for this project, research sponsor, was Department of Defense.
And specifically, who are you working with? What types of folks do you work with?
Big money in that research.
Well, it started in early 90s, National Highway Traffic Safety Administration. It is part of our government, civilian government, U.S. Department of Transportation. I worked from 1992 to 1996, 97 on mathematical modeling of human brain. NHTSA, for short, used this program that I developed in the study of real-life car crashes to understand the effect of head strike into the A-pillar. A-pillar is the connection between windshield and side window. 1996, I was invited to join Armstrong Aerospace Medical Research Laboratory. This laboratory is part of the United States Air Force at the Wright-Patterson Air Force Base in Dayton, Ohio. Back then, in 1996, women received all the rights that men had, and the question was, how the safety system of ejection seat perform for female. Body dynamics for female is different than for male. In the scope of this work that lasted about 15 years, I was involved in an analysis of 900 full-scale tests with male and female pilots. In 2007, now remember Afghanistan war, a lot of traumatic brain injury cases, and unfortunately many of our soldiers were released to civilian life with a clean bill of health, and actually they had the brain injury. So Congress appropriated over $100 million to the Department of Defense to study that issue.
Told you, big money in this
and
research.
I was fortunate enough to be invited as a scientific consultant into that endeavor. And part of that work, I had $1 million research grant. I chair a number of different committees that relate to biomechanics of traumatic brain injury.
Okay. You have taught not only in engineering school, but you've taught in medical school. Tell us about that.
That's correct. I'm an adjunct associate professor at the medical neuroscience department.
Peter Terry, welcome.
Different university.
Samantha's amazing.
70 miles north from Fargo, University of North Dakota. I'm not a physician, so I don't teach medicine, but I teach how injury occur. So I was involved in teaching team-taught courses and obviously teaching the mechanism of trauma. In addition to it, I was involved in a research project, the School of Medicine and local emergency room, and the objective was to apply knowledge that we have in automotive field, in military field, to medicine, into emergency room. Completely different fields, and medical students do not know much about what we know in biomechanics. Obviously, we don't diagnose injury. We identify risk factors. We identify likelihood of type of injury. Physicians do what they're supposed to do, diagnose and treat injuries.
Can we kind of, put a bow around your background as injury mechanics, what causes injuries, the forces that are involved in injuries?
Yes, that's what it is.
You've lectured, I'm sure, before?
Yes.
Around the world?
Well, yes. No, first of all, at North Dakota State University for 35 years, altogether as a professor for 40 years. But outside lectures, yes, at many different conferences throughout the world.
This is not the first time you've been in court in litigation, right?
That's correct.
Okay. You have been qualified as an expert in injury biomechanics. Give us an idea how many times.
I testified probably at least 80 trial cases since year 2000.
Around the country?
Yes.
Federal and state courts?
Yes.
Okay. Your Honor, at this point, I'd like to move for the admission of Dr. Chesky, I'm going to butcher it, CV, and for his admission as an expert witness in injury mechanics, biomechanics.
This is like a coach not being able to pronounce your players' names.
I will receive his testimony as an expert in injury. You said injury biomechanics?
Thank you.
Okay.
Doctor, can you tell us, in this case, you and I got together a few years back, what was your assignment as you understood it?
Well, I was asked really two questions. First question I was asked whether or not from biomechanical perspective I can assess severity of trauma that this particular individual sustained. And the second question was whether or not we can determine how fast that the vehicle, the Ford, was traveling at the time of the contact with the individual.
Now, you weren't talking about burn injuries here. You were talking about I'm going to call them orthopedic injuries.
Right. I talk about blunt injuries. I don't talk about the thermal injuries.
Okay. What did you review to be able to arrive at your opinion, sir?
Well, the most important for me was the medical records, the autopsy records. The medical description of the injuries were the most important. I also had the information about the type of vehicle it was involved. I received photographs of the wounds and photographs of the vehicle with the blood on the carriage.
Okay. You reviewed the autopsy and medical records. I'd like to show you, prepared a PowerPoint. I don't know if you have it, but I'm just going to show you a slide from your PowerPoint. You can tell me if this helps illustrate your testimony.
Okay.
Sounds like we're skipping the PowerPoint.
Is that a slide you prepared?
Yes, I did.
And what does it describe?
Essentially, it is verbatim statements from the autopsy record. As a biomechanical engineer, I'm historian as far as the injuries are concerned. I accept the injuries as diagnosed by physicians and present in medical records.
Okay. Does that help illustrate some of your testimony regarding Mr. Stermer's trauma injuries, forced trauma injuries?
Yes, my opinions are based on medical records because those are the objective evidence, forensic evidence in this case. So in the majority of my cases, I start with medical records as objective records and formulate opinion.
Okay. Your Honor, at this time I'd move for the admission of Defendant's Exhibit V. Victor.
Is it just the slide?
Just the slide.
Just the slide. I have no objection to just the slide.
Thank you.
What'd you say? V?
Victor.
Victor? V.
I'm going to show what we marked. Is that the slide you were talking about?
Yes.
Okay. Shows Todd Stermer, who at the time was age 42, 5'7", 180.
That's correct.
And now I'll blow this up a little bit and see if we can describe some of the injuries, and you can explain what these injuries mean to us.
Well, and maybe I can give you numbers, because really that's so small that I know what is on it. I have a hard time to read
All
it,
right.
you know?
Just tell us what the injuries are.
If you go to those are the injuries, and the first three injuries relate to burn. I really don't deal with that, but I include it in the analysis. If you go to number 4, okay. If you go to item number 4.
Give me a second.
Very good. We have 4 lacerations on the skull. So we have evidence of 4 separate contacts to the head.
Okay. Then what?
The next one, if I can lead that, go to number 5.
Okay.
This is the most words I've ever seen on a PowerPoint page before. Can you imagine what the rest of it looks like?
Okay. Minimally depressed marks, defects of the outer table of the skull underlying 2 of the lacerations.
Let's break that down. What is a depressed mark or defect? And then I'll ask you, what is the outer table of the skull? What are we talking about?
Skull is like a sandwich. We have a dense layer at the top and dense layer at the bottom, and we have this porous layer in the middle. This description indicates that only top portion of the dense layer of the skull was, as was described, depressed. Normally, if you have a linear fracture, you have a linear fracture all the way through the skull. It didn't happen. It just simply top portion was compressed. Now, it is important that that type of description relates to two lacerations. So already we are connecting the two lacerations to one event that is quite similar in nature. I mean, the chances are that you might have a very similar outcome from completely two independent blows. It can happen. But clearly this would be more consistent with head contacting something that is on one side and another side. There's a rigid object in one motion, head motion, with respect to the rigid structure, created those laceration and minimally depressed skull.
In two spots.
Two spots.
Okay.
Like an upside down frying pan?
Now, what I would like you to maybe skip to go to number 7.
All right.
Okay, so now we have a depression of outer area of the left parietal bone of the skull.
What's the parietal bone?
Side bone. If you look at the midline to the temporal area, this is parietal bone. So we have depressed area in that location. It's on the left. Now, if you go to number 10, now you have a depressed mark on the outer table of right parietal bone, underlying laceration. So what is important that we have in both areas, left and right, we have an outer area of the bone. So now we know that the two areas that the records refer to are on the side of the head. The size is somewhat different. The one on the right is about half an inch, the one on the left a quarter. That's not that critically important. Important thing is that the nature of the damage is the same left and right. So both of those happen from one particular event.
Okay. What else do we have?
Now I would like you to go to item number 8. Okay, V-shaped laceration in the midline, posterior, frontal / anterior parietal skull over the vortex of the skull. A lot of words, but midline is midline of the head. Posterior is the back. Well, the word frontal tells you is front / anterior, because anterior really means front. Parietal skull over the vortex of skull. So there's some laceration close to the vortex area. Remember, we have 4 lacerations. We explained 2. Now we are dealing with the third one on the vortex.
Where are these words coming from?
Directly from, by the way, notice that after each sentence, I have a parenthesis, document 1:17. That's document 1 in my list of material studies. That's the autopsy record. And :17, that's page 17. In addition to it, I attach the date for this diagnosis, 187.
Date of the autopsy.
That's correct.
Okay. Where are we going next?
And the last one really would be number 11. And again, talks about this 2.5 inch gaping linear laceration on posterior back midline region of paradial occipital scalp. Now, occipital scalp is the backbone of the head. So now we have evidence of contact that extends from the vortex to the back. And those are 2 separate lacerations as identified, and we have a 2 on the side, we have 4 lacerations.
Okay. Anything else we need to see there?
No, those are the most important aspect to us, because lacerations are AIS level 1. AIS stands for Abbreviated Injury Scale. It's a trauma scale that we use in civilian and military organization to link diagnoses to engineering parameters. Now we want to medical field and engineering field to communicate. And AIS scale allows us to do that. Based on AIS scale, we can use the evidence of the injury, and we have an engineering component attached to different level of AIS scale. Essentially, AIS scale is fatality scale. AIS level 1, 0 fatality. So all the lacerations that you see, the likelihood of fatality from it is 0. The next level, AIS level 1, is linear skull fracture. We don't even have linear fracture.
What is a linear fracture?
Well, linear fracture versus depressed fracture. Linear fracture, the skull gets hit and fracture. You have a line, fracture line for the skull. Depressed fracture, when you have additional energy that causes comminuted or complex fracture of the skull. Here we don't even have linear fracture because it doesn't go all the way through the skull. But still, I would assign AIS level 2 score according to the scale, because there is portion of the skull that is fractured. And probability of fatality is very low. The survival rate is 99.2%. So 99.2% likelihood of survival from this kind of injury.
And tell us that, were there any brain injuries involved here?
There's no indication of the brain injury. In other words, the bone heals, and very often there's no residual effects. The problem is that we have a soft tissue that might not heal. So in terms of the head injury, we are very much interested in what happened to the brain. There's no bleeding in the brain. Contusions or bruising, contusions is bruising, that happens if you get hit in the head and brain strikes the internal surface of the skull, it might bruise. Bleeding can occur. No laceration. So there's nothing in the brain tissue that was identified as evidence of trauma.
And the AIS-2 level would be considered what? How would you describe that level?
It's called moderate. You don't have evidence of internal brain trauma, and level of survival is 99.2%.
And in this particular case, you had pictures of the undercarriage of the van, and it tested positive for Todd Stermer's blood. Do you have an opinion, doctor, whether all the injuries that he suffered, all these traumatic injuries, other than the rib fractures, dealt with contact from the van?
Yes, everything is consistent.
I don't think you can opine on that. I think you can say those injuries are consistent or not, but we're outside of the scope here of what he could testify to.
I'm allowed to ask if it's consistent with.
Thank you.
That's appropriate.
Are they consistent with a single event?
They're consistent with single event, the interaction between his head and the pickup going in opposite direction.
Okay. Do you have a slide or a photograph that depicts the injuries to the skull and then also the components of the undercarriage?
Yes, I do.
Okay. Your Honor, just to advise, there's just going to be one picture of the skull from the autopsy showing some lacerations. And counsel has that.
May or may not see this one.
Yeah, as long as it's just the one slide in the report, yes. That was right above the one we've already admitted.
I believe that's Exhibit
Figure 1.
Q. Okay. Move for the admission of Exhibit Q.
And you? Yep, we have a
Go.
queue. That was this morning.
Figure 1.
We already have a cue.
Oh, you. I'm sorry, you. Sorry. Thank you, Ms. Heidi.
And jury, it sounds like there might be a little graphic here, but bear with us. We'll get it on and off the screen.
Thank you.
Mr. Mueller?
Doctor, can you show us?
Pardon? Yes, I'm admitting you.
Good. Can you show us what you're talking about in terms of injuries and tying it into the injuries of the skull?
Can we focus on the top left corner of this composite? And I prepared this composite. Right. So we are looking at the top of the head. The nose is up to the ceiling. And at first, let's look at the two lacerations from the side. Those are the two lacerations that we discussed initially.
This
then
one
we
here?
have the big laceration, and there are some small fractures, outer layer of the skull. And then we have a laceration on the midline in the vortex. That's the laceration. And if you look at the laceration to the vortex, the force applied was obviously into the head and backwards. So the vehicle was going backwards, so his head was moving forward to end up with this kind of injury. Relatively.
You understood that all the blood was on the front surface of the undercarriage components.
That's what I understand.
So, what does that tell us in terms of any of these other pictures that you're talking about on this?
Well, what it really is telling us that from biomechanical perspective, I see one event, his individual with the head orientation into the front bumper of the pickup, and the pickup going over his head, and those injuries took place.
Okay. Getting back to that first opinion about a single event, is your opinion, having read Dr. Markey's testimony and his autopsy, is your opinion consistent with his that none of these injuries were fatal?
That's correct. I am.
Then let's talk about what type of impact. When we talk about forces, we're talking about loads, right?
Yes.
Loads in your business?
Yes.
All right. Tell us, do you have an opinion, given all the material you reviewed, whether or not these injuries are consistent with a low-speed impact of the vehicle?
It is. Actually, cadaver studies show that head striking a rigid surface at 5 miles an hour, it's like 7 feet per second. It's like slow jogging speed, is sufficient to cause linear fracture. And the forces that were measured was 1,500 pounds. 5 miles an hour impact against a rigid surface.
So what does that mean in terms of, are we talking about low speed, high load?
Yes, I mean, low speed, 5 miles an hour is not the high speed. And if the impact happened, I guess not the right way, the wrong way, skull fracture can occur at that velocity.
But here it didn't.
It did happen. We have some minor fractures, which I would not again classify as linear fracture, somewhat less than linear fracture. So less than 5 miles an hour.
Do you have an opinion based on your review of the photographs, the medical records, the injuries, in terms of the relative height of Todd Stermer's body as to the vehicle on impact?
Well, the only thing I can talk to you about is where the head was. So the head to be somewhere at the height of the bumper or somewhere below, because they had to go under the carriage.
Finally, there's been some talk about the possibility of a frying pan being involved in this impact, in an impact. First of all, as a medical expert, do you deal in possibilities?
No, I don't. That's speculation.
In terms of your review of this case, do you have an opinion as to whether there is any evidence that suggests that a frying pan could have been involved in this trauma?
I don't see any evidence, because all the evidence that we have aligns very nicely in the sequence that I described to you. So more likely than not basis, there was only one event, the interaction of his head with the undercarriage of the vehicle.
And can you describe any significance to, I think you said, some symmetry between the lacerations?
It is. From very beginning, I mentioned to you the side fracture, position very symmetrical, pretty much the same extent of the fracture, meaning the same loads. So something there under the pickup, how it's designed, that there were two edges of sort that came into contact with his head in those two locations. And then there was less severe, there was the contact with the midline from the vertex to the back of the head.
Okay. Your Honor, just give me 1 second.
Okay. He's a smart guy. I don't know how he can testify that all these happened at the same time. The blow to the front, the V on the top, the verticals on the
Doctor,
side.
thank you for coming here from Fargo. No more questions at this time, Your Honor.
Ms. Eiderbean, any cross?
Yes, thank you, Your Honor. Good afternoon, Doctor.
Good afternoon.
So I just want to be clear, you study the force that an injury, what force it takes to cause an injury on a skull.
That's correct.
In lay people's terms.
That's very well described.
Okay. You're not a doctor of medicine.
Right, I'm a doctor of medicine.
You're not a forensic pathologist.
That's correct.
And you're not here to opine about injury patterns or that sort of thing on a body at autopsy.
No, actually, injury pattern is part of biomechanical evaluation, because we are talking about the forces. And we are very much interested in the pattern, because lack of pattern creates additional body kinematics, additional body motion. We are interested in that. So symmetrical pattern obviously tells us not much rotation either way, just uniform body position. So pattern is actually part of the geometry, part of physics. Not the physicians do not understand what pattern is. We all understand.
So I'm going to stop you there. You're talking about patterns of maybe where lacerations are?
Correct.
So you're not looking at like a pattern, like if somebody were to be hit with something with dots on it, that it would cause a pattern on their skin.
No,
We're not talking about that, right?
No, I do, we do because the type of imprint, you have a silly part, you put the finger, and somebody will ask us what caused this imprint. It's important that we will be able to figure out it was a human finger that left the imprint.
Did he say
so,
silly
no,
putty?
we are very much interested in the geometry of trauma.
Okay.
We are.
But looking at this, we're just looking at lacerations
So we have Lego silly putty.
and where they're located on the skull.
Lacerations, nature of lacerations, location of lacerations. More than that, the type of evidence of the skull fracture. Both sides we have just the top layer of the skull. What the chances are that random two forces come striking the head and only top layer of the skull is fractured. Not all the way through, or not at all. Well, the situation is very simple. It's some kind of symmetrical orientation, and will give you the same amount of force and approximately the same amount of depressed fracture. There are some small differences. One is a quarter inch, another was is half an inch, minor difference.
So when you're talking about the depressions, you're talking about depressions into the bone.
Yes.
And it could certainly be possible for there to be depressions in the skull created by different impacts.
Theoretically, yes, anything can cause, if it is forceful enough, to cause depression in the skull, sure.
Yeah. So each one of those could have possibly been caused by a different blow or a different trauma.
I don't deal with the possibility on more likely than not basis, no. Everything is so symmetrical. I can envision two separate blows and give you pretty much the same type of laceration and top of the skull fracture. That's so unusual. Typically you have no skull fracture or fracture all the way through. So somewhere in the process, the force ended.
So doctor, I just want to stop you there. You have the two that you're saying are symmetrical, but you also have one on the top and one on the back, correct?
There's no fracture. There are just lacerations.
And indentations?
Indentation, yes.
Okay. And so all of those are then what we would classify as blunt force trauma?
Yes.
Okay. And I was taking a look at your report, and I think you testified as to what you reviewed, and it included the autopsy report, the car specifications, the trial testimony of Dr. Markey, and the photographs. Are those the photographs of the autopsy?
Yes, and you saw also some photographs of the undercarriage of the vehicle.
Okay. So you didn't review any of the testimony that any of the witnesses have provided?
No.
Okay. And a blunt force trauma to the head, if somebody were to hit a skull, a human skull, with an object, would you expect to see the same sort of indentation or laceration?
Sure. You can hit the skull any place, and you can get a laceration, an indentation, a skull fracture. Sure, it can happen.
And so basically what you're looking at is the amount of force that it would take to cause these lacerations, and you're concluding that they're not fatal.
Correct.
You're not here to talk about any of his other injuries.
No, just based on skull and lack of brain injury. If there will be any bleeding, contusions, laceration, you will hear me talking about that. And that injury will have a higher AIS score than skull.
So you are aware, after reviewing the photos, or are you aware that there were actually several different spots where there was blood underneath the van?
Yes.
More than 4?
Yes.
And are you aware there were multiple injuries that were seen not just on the head, but also on the body?
Yes, if you look at the medical records, I list some of them: arms, thoracic, rib fractures, and so on. Extremities, yes, but those are of minor significance in terms of the fatality.
In terms of the fatality. But we can agree that there's definitely more injury than just on the skull.
Yes.
And we can agree that there are multiple points underneath the van.
Yes.
And you can't say what part of Todd's body touched what part of the van.
No.
Because that would be speculation, right?
No, I would probably, if I will have exemplar van and three-dimensional model of the skull, I bet we could go there and match what portion of the undercarriage create those two imprints. Lacerations, they'll be more difficult, but if you already have a one point identified, the indentation to the side, you're in a good shape to identify where the head was and probably find the location for lacerations. But no, I didn't do that.
Well, and there, we can agree there's more than one laceration. So you'd have to match where the laceration on the back came from, the laceration on the side, the laceration on the arms. You can't do that. That's not what you're here to do today.
It didn't do any other lacerations except the head, but the fracture on the side and laceration goes together. And then you have an impact to the top, and then flexion of the neck, and you have a continuation to the back. Although there was no injury to the neck.
So I'm going to ask you that question again because I don't think you answered it.
Okay.
You're not here to match.
Do we need the commentary?
Yes, that's fine.
You're not here to match the injuries that he
Yes.
sustained on his back, his side, his arms, to any particular portion. You've only analyzed the head.
That's correct.
And you can't say, sitting here today, if it would have come from a blow prior to being hit with the van, right?
That's correct.
And you can't say what particular blows on his head came from the van.
No, as far as the blows to the head,
Your Honor, it's not unresponsive. I just needed an answer. Thank you.
Are you moving on, or?
Yeah, I'd like to move on.
Okay.
Thank you. And I just want to be clear, you've reviewed no testimony from any other witnesses, and you've seen no testimony that was provided that somebody claimed that Todd Stermer was hit prior to being hit by the van with a blunt object.
correct. Have not seen this testimony.
I have no further questions for this witness, Your Honor.
Fence
Two
jumps
more
up.
before I wrap up, Your Honor. You did account for in your findings other lacerations on his body, right?
Oh, I knew where they were. I identified this in the medical records, and some of them I listed in my summary.
Okay, if I go to number 14,
This man made a PowerPoint presentation, put all the information on one slide.
you noted the laceration on the right rear shoulder and upper back,
Correct?
and the upper left arm,
Correct?
and the lateral back and chest. So you noted all those.
Yes, I did.
But they didn't have to do with anything having to do with your analysis of whether or not these injuries were serious enough to have any type of chance of being fatal.
Correct. It's AS, any lacerations, abrasions, AS level 1, 0, likelihood of fatality.
Your ultimate opinion, or one of the opinions you have, though, is given the nature of these lacerations, the symmetry, it's more likely than not that everything happened from a single event, all those head lacerations.
Yes, the
And
head
fractures.
lacerations, yes.
And fractures.
And what?
And fractures.
Yes,
And they would have been from the van impact.
definitely.
Thank you. Anything else?
DSN,
I just want to be clear.
gifting a membership.
You said that the two on the side of the head were symmetrical. Those would have maybe come from one incident. But then I believe your testimony was that the other ones were not then associated to the two on the side.
It might be. I'm just saying that those two very much symmetrical, and then we have a top and extending to the back. I did not match with the exemplar vehicle, so I don't know if the structure, undercarriage structure, that will leave the side depression, also have close a surface consistent with the contact with the top. If it does, everything happened right there. If not, it happens somewhat later.
And that would address 3 out of the 4 lacerations.
No, because this laceration on the top, there's extension. Everything is the midline of the head, so it's extension to the back. Now we have 4.
Now we have 4. Whisper, 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 whisper.
I just wanted the slide that was showed a laceration, and I'm just going to show you your slide. Showed a laceration on the top of the head. That's the laceration we're talking about here, right? The one on the top.
Yes.
And so this photo doesn't show the laceration in the back.
This photo doesn't, because the head is laying on something, so it doesn't show the acceptable laceration.
So the laceration on the head goes, for lack of better description, from ear to ear side.
No, go from it's extended, have certain width, and goes from the top to the back.
So what we're looking at in this photo that you put up on the screen, is this the face?
That's a face.
And this shows the injury going across the top of the head.
That's terrible.
This
She
way.
has to ask that.
No, there's an impact and tissue bursts that way.
Okay.
So if you have a sphere and you hit material, you get a laceration perpendicular to the direction of the force. And some of the tissue will be pushed in the direction of the force. That's exactly what happened.
Okay. And then this does not show the laceration in the back of the head.
No.
Because the body is laying on its back.
Yes, but it's in medical records.
Okay. And you can't say where the blood came from on the van, like in the different areas in the photos you looked at.
No, I mean, other areas, the bleeding, it could come from different areas. And remember, blood is splattered. It just goes in different directions. So sometimes it's difficult to pinpoint where exactly, what's the original source of the blood.
Especially if you have lacerations on your head, your arm, your back, and your side. Would you agree?
That's correct.
I have no further questions, Your Honor. Thank you.
To make sure we're clear, in your expert professional opinion, you saw no evidence that's consistent with impact from something like a frying pan, right?
That's correct.
Thank you.
Not.
Yes, Your Honor. I just want to clarify, you testified that you can't say that a blunt force object could not have caused one of the lacerations.
No, I said, in general sense, laceration can be caused by a blunt object, period. Now, totality of the evidence, or more likely than not basis, how everything is lining up. That two contacts on the side, and one extended contact from the top back.
But the totality of the circumstances would also take into account testimony that the defendant said she hit him with an object. Would you agree with that?
And it goes way past the
Women's, I'm going to sustain the objection as to foundation.
Did you take into account any of the testimony from the trial?
I was aware of this fact from reading trial testimony of physician, and on more likely than not basis, I don't see any evidence of that. I just see the evidence on the head from contact from undercarriage of the fall.
But you can't say, from what your prior statement was, you can't say that another blunt force object did not cause one of those lacerations.
More likely than not basis, everything fits the contact with the undercarriage.
Unresponsive, Your Honor. It's unresponsive.
Responsive. He's answering the question.
Sir, if you could try to just, I think if you can answer it with a yes or no, if you could do that.
Is it possible that one of the lacerations was caused by a different source of a blunt object?
Possibility is speculation. Is it possible? Yes, you might have an impact and no trauma. Then we won't know that really happened.
Your Honor, it's unresponsive.
You said it is possible.
It's possible.
Thank you. I have no further questions.
Your Honor, you also said possibilities are speculation, right?
Yes, it is.
And do professional experts engage in speculation?
No.
Why not?
Well, because there's infinite number of possibility pretty much for everything that happens. So we are evaluating things from more likely than not basis. That's why we are evaluating the pattern. Everything fits in one particular motion. More likely than not, this is how it happened.
And one single event being the van impact?
Yes.
Thank you.
You can't line up those injuries to the parts of the van.
Objection, asked and answered.
I'll allow it. She's asking the exact parts of the van.
No, not specific parts. As I said, I did not match the specific geometry of the undercarriage.
Therefore, you're speculating about how these injuries occurred.
Absolutely not. Because I know the outcome. I see the blood in the undercarriage, so I know the body was there. And I see the type of trauma, laceration, and under laceration, I have some evidence on fracture. I can guarantee you that's a rigid object in some kind of rounded edge that came in contact. And we have a symmetry to it, consistent with similar structure of the undercarriage.
I have no further questions, Your Honor.
Thank you, Your Honor.
You good?
I'm all set.
Okay.
Well done.
Thank you, sir. Oh, I'm sorry, jury. They often have questions. How could I forget?
Zoom out. He held his own. He did well. I actually like that witness. He's basically saying because the body was found with tire tracks and blood under the van, then all the injuries then came from the van. I think there could have been a line of questioning saying, did you observe any injuries on the body that you could determine did not come from the van? The answer would be yes. There were significant burns all over the body. Is it possible that based on the damage to the individual and knowing that he, in the state he's in, the burn state he is, came running out of the house, is it possible that there was any other injury? There's the possibility thing again, but I think that's evidence you could consider to say there was a traumatic event prior to this as well. I think the jury gets it, but I think this isn't the win that the defense wanted, but it sure is much better than the fire expert. Is this the last witness? Is it the last witness? I really like him. I'd like to see him testify in more trials. I don't know, Karen Reed, are you available? What's up? You'd have to speculate in that one, I think. How does he account for the simultaneous hard object on both sides of the head at the same time? If you're being struck by a van, the van is on top, the van is in front. what is the other object? Is it the ground, the soft mud that was so easy to get stuck in? What's the other object that has equal force on the other side? I just don't know. I don't know. Oh. Hang on one second. I've got to send a text really quickly. Watching Brian Koberger still going on. They're back. They've been talking for about, 30 minutes or so now. They're still arguing up there in Idaho about the evidence, what will be coming into the Brian Koberger case and what will not. Got a good little crowd over there if you want to join, if you're interested in that.
I have some questions from the jury. In your biomechanical analysis of the injuries, are you assuming that the object being struck, namely the skull, was in a stationary state at the time of impact?
No, it doesn't have to be. The relative velocity has to be about 5 miles an hour. So it could be 2 miles an hour and 3 miles an hour. 2 miles an hour of the skull and 3 miles an hour of the pickup.
If so, could the severity and analysis of the injuries be altered if the object, the skull, was in motion either toward or away from the vehicle?
No, the severity is what it is. So the 5 miles an hour is sufficient to do that. And it could be skull going 3 miles an hour away, and then the pickup will have to be going 8 miles an hour into it. So the differential, 5 miles an hour.
Would you clarify the direction of travel of the van during the impact event?
The only thing I can tell you is the direction of the van with respect to the head. The head is pretty much directly into the bumper, a little bit under the bumper, and the van is coming over.
Did you computer model the impact event?
No, there's no reason to do a computer model because the evidence are so straightforward and based on the questions that I was asked. There was no need for that.
Based on your examination of the data, do you think Todd was laying face up or face down when hit by the van?
It was face down. We know that at the very end there's some medical observation about dirt in the nose and dirt and grass in the mouth. So definitely it was face down, but somewhat off the ground initially when the impact occurred, but facing down.
Okay, thank you, sir. Counsel, any questions in light of those questions and answers?
Thank you. That face down is based on your review of the medical records, the autopsy records, and the photographs of his face?
Yes.
Okay. 1 second. Would you agree, based on your biomechanical engineering background, that if all the blood spots are on the front side of the undercarriage components, it would mean that the van was going forward?
Oh, you're over his glasses.
Yes.
Yeah. And simply, when you're asked about the skull being stationary, absolutely still, versus there could be a relative movement of the skull with respect to the bumper.
Oh, the relative motion of the skull before the impact, I don't know. There's no evidence. So from physics perspective, I cannot tell you. I know that what was the orientation at the time of impact? Quite symmetrical. It could be some waving of the head before, but at the impact was quite symmetrical. And vertical because of both lateral laceration and skull fractures are so symmetrical, so could not be tilted to any extent left or right.
What do you propose
It was
caused
face
those?
down.
It was facing down because we have the side impact and then we have a top and the continuation to the back.
Thank you, doctor. Appreciate it.
So, I'm sorry, I'm not, I just want to make sure I clarify. So you're saying if somebody were moving away from the vehicle and the vehicle then was coming from behind, then it would be higher than 5 miles per hour?
The actual velocity of the vehicle would be higher if the body would be moving, let's say 2 miles an hour back, then it would be 7 miles an hour.
You got hit from behind?
If the body were moving 5 miles an hour forward, then the vehicle would have then traveled faster.
If the body is moving 5 miles an hour forward, the vehicle could be stationary. And you have 5 mile an hour impact.
Hit
Well,
from
the
behind?
vehicle would not be stationary when they make impact.
I know, but
Unless the body ran into the vehicle, correct?
Right. That's the test. The 5 miles an hour test in skull fracture was done that way. The surface is stationary and the head hits the stationary rigid surface. So the relative velocity between the head and the impact surface has to be 5 miles an hour. It doesn't matter.
So if the object is going faster, then the vehicle would have to go faster in order to then create that 5 mile an hour.
You have to give me the direction because it depends what direction. But yes, the difference in the velocity, the vehicle has to be going 5 miles an hour faster in the same direction, right, in the direction of the skull to get the fracture.
I have no further questions, Your Honor. Thank you.
Oh, I do.
I do.
If the body was going 5 miles an hour, that you said is jogging speed, correct? You understand the facts of this incident is that Todd Stermer was likely on fire?
So we might have
And
been
you would
running.
also expect lower body injuries if he was upright, wouldn't you?
Your Honor, I'm going to object. I don't think he's specialty will let him opine on that.
It's exactly in his wheelhouse based on the questions I received.
I will overrule that objection.
Thank you. Did you see any lower body injuries?
But the abrasions that we talk about, back and shoulders. and
No
arms.
fractures, no nothing?
No.
Okay. You would expect if a body was running and got impacted with a van, you'd have to be, and let's do the quick math, for a change in velocity of 5 miles an hour, if the person's running away at 5 miles an hour, the vehicle would have to be at 10, wouldn't it?
Yes.
Right. You didn't see any evidence of that, did you?
No, there will be fractures and there's none.
Thank you. Have a safe trip back to Fargo.
Thank you.
Jury, do you have any more?
Jury, any other questions? May he be excused from his subpoena, counsel?
No subpoena, but he
Okay.
may be excused.
Okay, thank you, sir.
Thank you.
Counsel, can you approach, please?
Looking at the clock here, it is 3:37 in the great state of Michigan, and rapidly approaching pumpkin hour for them, which I believe is 4:30. So we're just under an hour away from a hard stop, assuming there's nothing else the court has planned for today, which occasionally they do have some afternoon outside business to conduct. What are we looking at? We're looking at the clerk. They're looking back and forth like they're making a decision. They're getting input from each other. State shaking their head. Linda watching like a tennis match, ping pong back and forth. What if the state got it wrong? I like to ask myself these questions. What if the state got it wrong on, I don't know, say the gasoline? I've been debating. I have an experiment I can show you where I can dip an item of clothing. We can even use polyester if I can find some in inflammable liquid, and I can light it on fire, and it will burn until it extinguishes itself, and the clothing will be just fine. Now, it doesn't work as well with gas. But how did the gas get on him? Amber just barely got off the phone from that meeting. Nice of you to show up. No, just kidding. Could it have been an email, is my question. Could the whole meeting have been an email?
A short break, hopefully, maybe we'll make it your usual 15 minutes, and we'll go as late as close to 5 today.
Oh, we're working late. We're working till 5. That's exciting. Judge is trying to meet the schedule. The jury's leaving right now. Any chance the van leaked gas and spilt on him? I did not see on the undercarriage pictures of the van an exposed gas tank. I would say most likely no. Because if he was on fire when she ran him over, the van would have caught on fire if it was leaking gas. The fact that she ran him over makes her guilty of murder, in my opinion. This is a fun little thing.
Okay. So at some point I want to sit down and go through those. Yeah, well, Joe usually types up kind of a list of possible stuff. So I'm trying to think. Yeah, we can go off the record.
We're going off the record, which means camera has to go zoop.
Record. I'm just trying to figure out
We're just trying to figure something out. We're off the record. It's scheduling. We may be at the very end of this case. The one thing the defense is not disputing is that she ran him over. As a matter of fact, I think if you just presented a document to the jury that says we hereby stipulate that on this date, in fact, Linda did run over Todd in the yard with the van, they'd sign it in a heartbeat, with the caveat that they thought it was an accidental, that she didn't see him when she ran over him. They want that part to be the accident. They want that to be the entire case. If they could get the rest thrown out, they would be happy with a worst case scenario conviction of just her running him over with the van, because they were non-life threatening. They'd like that to mean that it was not attempted murder. I don't think you can just assume because he did not die from being hit by the car that thus it was not attempted murder. If she really wanted to kill him, she would have been going at 25 miles an hour. No, I don't think you can get there. A vehicle is a deadly weapon. Hitting someone with it is intentionally, I think, would be an attempted murder. Is she testifying? Did I hear that somewhere? If she does, this case just gets to a new level of weird. We've already had Legos mentioned. We've had Silly Putty mentioned. If we get Mr. Potato Head mentioned, that will be the trifecta, and we'll have all 3 toys in. Rarely do we get 2 of the 3 in a trial, but did she allegedly hit him with a frying pan, then a van, then burn him? Jonathan, the frying pan, they hit him with the frying pan? That testimony is coming, I think, through the jailhouse snitch that testified to something. Keyboard mic is hot. It's a rare hot mic. TYO Toys will have a new intro. We did have the talk about cars being formed from melted down metal. I think they're talking about die-cast cars, which TYO Toys has in spades. He made me this one. This one right here. It says Top Mark Media on it. It's a Sprinter van. I don't want to open it. It's pristine, new in the package, which has a little bit of dust on it. I apologize, Phil. Let's focus. This is worth the focus, right? It says Pickles, not politics, in green. It's pretty cool. Got a 15-minute break, but it's going to be just a minute here. I think somebody bumped the volume knob. Bertie, you missed a little bit. I think you missed most of the, depending on how long you've been gone, you've missed a lot of the state's defense case. TYO Toys, Phil, you'll see him in chat. He actually, let me do this properly because I didn't get the shout out properly for him earlier. Hang on a second. TYO Toys, Phil says, my Elantra is not a Sonata, said Bob Mata. 24 months, OG. Welcome to the gallery, Phil. Thanks. Love having you here. Phil does great work. He puts together some of the best moments from all of LawTube and LawTube adjacency on YouTube, and puts them together in little highlight reels that are hilarious. Really, really good stuff. Creative Bee, Debbie says, in my opinion, I'm always right, except when I'm wrong. Also an OG, Debbie, thank you very much. Debbie made the plaque that's sitting over my shoulder right here. That one. Congratulations, another OG. DSN gifted a membership. Thank you, DSN, and DSN gave a super sticker as well. Thank you both. Extremely generous. Email has not worked. This was the meeting. This is where you told them, if you don't change things, I'm going to be a mod full-time and devote all my attention to the Recovery Addict channel. That's where you just laid down the law. Would you, could you with the pan? Would you, could you in a van? Kills bells. I love the reference to Dr. Seuss. The name escaped me just for a minute. Green Eggs and Ham, one of the best books ever written. And just to answer the question so it doesn't go unanswered, I would not, could not with a pan. I would not, could not in a van. That was the proper response. Virginia, you did miss a little spice on the end. It was probably, the testimony wasn't as heated as the cross was, like the back and forth between the state and the defense. They were really jockeying for the last win on that one, and it got pretty, I don't know how many times we ping-ponged back and forth, but I think we had 4 or 5 directs and 4 or 5 crosses. And jury questions with more after that, so. There's a good song. That's from back in the big hair bands days. Hop on Pop. Also a good book. This jury has had some of the best questions. This last round particularly, probably the best questions of the trial. hot mic is just noise. I'm going to turn it off for a little bit. For those that are curious, Brian Koberger is still doing his thing
laid out.
Up in
What's
Idaho.
on each floor, where the bedrooms are, how the first
Well,
floors.
for it to be demonstrative evidence, what's important is whether it explains the testimony of somebody on the stand and helps the jury understand it.
Yeah, that's still going on up there in Idaho. Hey, Mrs. R.A., how are you doing? Hey, did you bring me something? Oh, a young one? No. No, nothing? Oh, she just wanted to say she loves me because I'm apparently that good. No. No, she said no. She said no. I love you anyway, in spite of it. Okay. Thank you. Kelly H. just gifted a membership. Thank you, Kelly. I appreciate it. I had Dr. Seuss books when I was born. I was a kid in the 60s. They were good books, and they're good books. I got an A in a college. I don't even remember what class it was. It was something in the English language lineup. It was an advanced class in not writing, but like, man, what are the other things? Not reading, not writing. It was like argument and persuasive essay. I don't know what it was, but I got an A in that class because of Dr. Seuss, and particularly a Dr. Seuss paper, because somebody did a paper on Dr. Seuss and equated some of the stories that he tells to main issues of the day, and some of them were political and everything, and the paper was fantastic. I don't know what went wrong on the grading, but that teacher absolutely loved that paper and gave me an A for it. It was not my paper. I did not write a paper about Dr. Seuss. I wrote something completely different about a family member who's long since deceased. So whoever out there who failed that class because of a poorly written and hastily written paper about somebody's family member, I apologize. But I needed that A. And yeah, I don't know who it was, but I got credit for it. And I would run into her because I used to go up and film basketball games, NCAA basketball games at the school. After I graduated, they'd call me up and hire me as a contractor for a couple games. And she has front row seats because she's a professor. And so she'd sit there and she's like, "Oh, Scott, I just want to say I love that Dr. Seuss paper. Thank you." I'm like, I love it too. You know, I mean, honestly, if it's just between the two of us, I am also just as big a fan about that paper as you are. But I don't know how she mixed up the grade. I mean, I got an A. I didn't think I got an A paper, but she always tells me how wonderful that paper is and then thanks me for it. Chris Wallace says, so many trials, so little time. Yes, it wasn't speech. It was something else. Critical thinking, something. It wasn't really debate. You mix up defense and prosecution a lot. I'm so confused. It's easy. Think of the one that I didn't say, and that's what I meant. So that's the answer key. I do apologize. I wish they had different names. Was the jailhouse snitch the one they died and they read? Yes, it was. Selena K gifted a membership. Thank you, Selena. We're thinking of you. We know you've got that fun surgery coming up. But things are going to be so better once the surgery's over and the healing's underway. It was a class on ethics. My wife comes in and ouch. I don't think it was ethics. Scroll up, please. How far? Here's one. Oh, I keep scrolling up. I miss a lot of posts. I apologize. Kristen Vasquez says, I feel like my head is in a blender after that. It was crazy. Chris Wallace, so many trials, so little time. Here we go. Rebecca comes in and says, Buttercup sends hugs and sugars. I've counted over 40,000 mosquitoes so far. Count more. Catch them all and count them all. I would not mind if mosquitoes didn't exist anymore. I mean, other than the fact that you would be out of a job. That part would make me sad, Rebecca. I really would. But I don't like. There have been years, like entire years that went by where I did not get a mosquito bite, and it was not because I didn't go outdoors. That's more the case now. But there have been entire years where I did not get a mosquito bite, and then there are other years where I'm just like a walking blood bank for every bug. So if you fans over on Trial TV chat, it was great. Squeegee of Justice, making it happen over there. Misconduct, that is great. We love him over there. Maybe it was sociology. I don't think I took many of those. That seems pretty advanced stuff for my degree. Think an inch deep, a mile wide. But it was something it was writing and reading and stuff. Whoa, what is going on in Atlanta? Just got an alert. Police chase in Atlanta. I wonder if there's going to be a video on that one. All right, it is quiet here. I was saying Koberger is going on.
This is an exhibit that's constructed outside. It's done in preparation for court. There were experts that took the 3D imaging to make this. There were photographs that were taken to make this. There's a process to construct this and to take it to scale, which might have made some sense because things would be there where they're supposed to be. And by things, I mean walls, I mean doorways, I mean angles of hallways, I mean lines of sight. Those things would be there where they were supposed to be if we were doing this to scale. But to not do that and call it a demonstrative exhibit so they don't have to tell us about it is really misleading to the jury. And there's a lot of danger for the jury to be completely confused by that.
We're gonna leave that. They're obviously arguing about an exhibit the state wants to present about the Brian Koberger, the scene of the crime, right? Because that house, the layout is complicated. It's not like your standard house. Understanding where everything was and the multiple levels and who was where. It's going to take a little bit of explanation for the jury to understand that one. And obviously the house has been demolished. It's gone now. There's no jury view and walkthrough. It's been leveled. And BK is there. If you look, he's
now
there
is
in
to
the light
test
blue
the
shirt.
state's model before it gets in front of a jury, before different witnesses use the state's model to say, this is where I was and this is what I could see.
Yeah. Anyway, good stuff. BK's there. His family is not at this one. This defense says the parents are not there because they can't afford to fly back and forth for every little hearing. They will be here for the trial, though, and they've argued previously today to not let the state just put them on the witness list as a potential witness to keep them out of the courtroom. The state said they're not going to do that. So, all right. Never understand why they demolished the house before the trial. It was a huge draw for crime junkies. Huge. And I think it was bad optics for the whole school to, come check out the school and see the site of the murder. Yeah, they wanted that thing gone. Wondering why the Koberger trial is going to take 3 months. It's going to take a while, yeah. We're back. Break's over.
Okay, back on the record. People versus Linda Stermer. Any matters to address before we bring the jurors back?
No, Your Honor.
None, Your Honor.
Okay, we'll bring in the jury.
Court's a little bit empty here today. Not as many people as we've had previously. Maybe they'll be filing in now that we're back. Starting up, bring the jury in and see what the state has or what the defense has left for today. We are at 4 o'clock. She said we wanted to go till 5. She told the jurors that. So to me, that sounds like that's another witness. Just in time. You made it, Jade. Welcome. Here we go. Jurors taking their seats.
Welcome back, Terry. Mr. Mueller, you may call your next witness.
Thank you. Greg Stormzan to the stand, please.
Before you have a seat, if you raise your right hand, do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. And once you're settled in, we'll have you give us your full name and spell the last, please.
Gregory James Stormzant, Stormzand.
Sir, I'll have you move that microphone closer to your mouth so the jury can hear you. Thank you. Mr. Mueller?
Thank you. Thank you, Your Honor. Good afternoon, Mr. Stormzan.
Afternoon.
Sir, can you tell us, what is it you do now for a living?
Retired.
Back in 2007 in January, what did you do for a living?
Back then, I was the Assist District Fire Investigator, which is out of Grand Rapids, Michigan.
Do you
Michigan
folks at the
State
Michigan
Police.
State Police have different areas and districts that you cover?
Yes, sir.
You were actually a certified fire origin and cause expert?
Yes.
How long have you been doing that? At that time, 07?
At that time, I got in the State Police Fire Investigation in 1999. I completed their training in 2000, so it's from 2000.
Okay. Back in January 7, 2007, there was a fire at the Stermer residence in Lawrence, Michigan. Your name came up as being part of an investigation on January 8, 2007, the next day, with a man named Scott Leroy. Do you remember at all going to the Stermer house in Lawrence?
Just vaguely since then, yes.
At that time, if you were 2000 and Mr. Leroy was certified or became a fire inspector in 2001, wouldn't you have had seniority over him?
It's not much of seniority. I've been in the unit a little longer than he had.
Okay.
I was in 99. This is 2001.
Would he have had jurisdiction over this fire because you folks work in districts or something?
Correct. Yes, it'd be his area of responsibility.
You were there then to assist Mr. Leroy?
That's correct.
Okay. Do you recall participating in any type of investigation at the scene?
Not specific investigation. He asked me to do a scene sketch of the residence, basically do the footprint, basically the outline of the house.
Okay, let me, if I can. May I approach, Your Honor? Thank you. Just going to show you something. Does that, in the upper right corner, can you just tell us what you're looking at, just to kind of jog your memory?
The upper right-hand corner would be the case number 04-18-07, the date, sketch not to scale.
But it's just GJS are your initials?
Yes.
All right, that's what you're talking about.
Okay, yeah, that would be my initials. That's how I know I did this one.
Do you recall the damage to the level of the house?
It was, recalling from the, thinking back, it was pretty severe, basically over the living room area of the house, which is on the main floor.
Okay, let me show you a photograph, and we can either look at it on the overhead or if it's easier for you, just on this blow up. But does that bring back, yeah, that looks like the house we did.
I'm going to object, I guess it's the lack of foundation, Your Honor. I don't know that he's ever had this view of the house before.
He was there on January 8th with Mr. Leroy.
This has been admitted, yes, but my concern is a foundational issue with him testifying for this. I don't know that he was ever up in the air in this case.
Why don't you lay a foundation?
Sure, you were at the scene, correct?
Yes.
And did you even look in the house or walk in the house?
Yes, did a walk around, and to the best of my knowledge, I thought that to the best of my recollection that Scott led me through the house and a quick walk around and say what happened and all the general description of what he
Does
saw.
that jog your memory as to that's the house we're talking about or no?
That appears to what the house that I remember looked like.
Okay. Did you take any photographs that day?
I don't recall taking any photographs.
Did you make any reports for your investigation?
I did not.
Other than these
Other
two
than I
sketches?
was asked to do the scene sketch, yes.
When you're doing a scene inspection, obviously this is considered a big loss, a total, lot of damage. Yes?
Yes, sorry.
Not every fire is the same. Some are kitchen fires, right?
Some are very small, yes.
All right. When you have, and especially, not that you treat anything else differently, but when you have a death case, it's a serious, serious case.
I'm going to object, Your Honor. I think the issue is we're not qualifying him as an expert in cause and origin. He sounds like he's testifying as a lay witness. Now we're asking him about how an investigation is conducted. I don't think that he's...
There are, again, I know there's a legal objection.
Are you objecting as to?
Oh, relevance and he's not an expert.
Okay.
He's not named as an expert. He's talking about his experience. He's even more experienced than Mr. Leroy, so he's talking about excavation, which is the heart of this case.
Oh, I mean, I think it sounds like it's an expert question, so I'll sustain the objection.
In this case, do you recall participating in any type of excavation of this damage to this house?
No, I do not recall doing an excavation.
If you had been part of an excavation of the house, would you typically do a report given your experience and training?
I would, depending on if there's anything significant that we found in the incident, I would maybe do a supplemental report if requested by the senior, by the officer.
Certainly would be important to do an excavation in order to find something significant, right?
It can be, yes.
Okay. And despite you were in an assistant position back then, correct?
Yes. Yes, sir.
You don't recall doing anything of the sort? Reports, photographs, anything?
No, sir.
Thank you. I don't have anything else.
Mr. Blair?
No questions. Come on, just say no questions.
Good afternoon, Mr. Stormson.
Afternoon, sir.
What was your rank with the Michigan State Police at the time?
Specialist sergeant.
Specialist sergeant?
Same as, Mr. Leroy at the time.
Okay. Mr. Leroy, do you want your iPad? Oh. You want your phone? Sorry. You can hand it to you. I just don't know if you want to touch it or not.
You break it, you bought it.
You break it, you bought it. Do you want your iPad? You break it, you bought it.
And so you were both specialist sergeants, correct?
Yes.
Sometimes referred to as detective sergeants?
Well, detective specialist sergeant, call us, technically my badge said specialist sergeant, so yeah.
So you were both of equal rank?
Yes, sir.
And in the hierarchy of the Michigan State Police, there are sergeants, and then there's actually like a lieutenant above you guys that's the manager of everybody, correct?
Correct.
And so on the 8th of January, you were actually just called down as an assist to Mr. Leroy, correct?
That is correct.
And you were there to just kind of help him with whatever he might have needed help with, correct?
That is correct.
And would it be fair to say your memory of what you did that day is fuzzy?
Yes, sir.
Don't necessarily remember everything?
Correct.
And so when you say, when you asked questions about an excavation, you don't specifically remember doing an excavation?
I don't specifically remember it. I thought we might have, but I don't specifically remember.
Okay, you thought you might have.
Yeah, but how could I answer that? Through the years, had so many fire investigations, we've worked with each other that they all get pretty foggy after the years.
And would you agree with me that it's pretty much state police protocol that whoever's like the lead on a case writes the report?
That is correct.
And that sometimes people that assist don't necessarily write supplemental reports?
Correct.
And would you agree with me that what you had on January 2007 was basically a fairly limited role at that scene?
Yes, I would say that.
Okay, all right, thank you. I have no further questions.
Yeah, so you're telling us that if you had done something significant as an excavation of a total loss, that you wouldn't have written any report?
If I would have done
If
excavation.
you would have even assisted and helped in doing a major excavation, you wouldn't have written a report to account for your
I
day.
might have, depending on what we found, or if nothing. Normally, lots of times, the senior investigator, the person writing the report, would put in, was assisted by so-and-so doing this, taking photographs, or whatever the specific request was done.
Okay. You would certainly expect a thorough report to be done, though, right?
Or,
Yeah, I didn't ask him that.
What's the objection?
Ask and answer.
I'll overrule that.
Go ahead. You would certainly expect a thorough report to be done.
or in the report, a section would be during the excavation, so-and-so, you found this or that.
All right. Not simply omitted.
Yeah.
Okay. Thank you, sir. Thank you for your time.
No.
Jury, do you have any questions of this witness?
No questions? Excused from subpoena if he's under one?
Yep.
Yep.
I don't
Sir,
have, I do have one subpoena.
Okay, sir, you're excused from subpoena. Thank you.
Thank you, sir.
You can go get your box of
You may.
lotion tissues. Get your box of lotion tissues and curl up on the couch. Drink yourself some, I don't know, a hot lemon drink might be good. He's definitely suffering. He's got a cold. Poor man. Some chicken soup. It's good for the soul and for colds. All right, that was a nothing burger. It was not much. Defense is complaining about something. He's had his common complaint is that there's I suppose there's an objection in there somewhere, right? That's his go-to, right? And he does that as soon as there's more than like 3 words out other than objection, Your Honor. State's telling him how it is. He says, fine, whatever. Judge has said we're going till 5 o'clock. Linda hasn't been as involved.
Jury, after I said we'd run till close to 5, I'm going to let you go early today. So, and come back again tomorrow at 9 o'clock. Remember your instructions. No discussion of the case with anyone else. No media, no social media, investigations, research, anything of the sort. Okay? You can leave your notebooks in your chairs and report directly to the jury room, and have a nice evening.
So as they split, we're going to wrap it up here. This was a fast open. They started early back from lunch, so I thought we were going to bring the guys from Koberger over here when we were done, but we might go over and join them. I'll be in chat. I won't be on screen for that, but Koberger hearing is going on, and it's getting some spice. It's getting spicy. They're deciding all the evidence that's going to come in the Brian Koberger case. It's going to be interesting. I might have time to go to the post office. I've got to get something, and it closes in 18 minutes. Might be able to get there tonight. Let's see.
Counsel, the jury's left. Any matters to address?
No, Your Honor, I think we'll be here early to talk about juries.
Jury instructions, 8:15.
8:15 sounds great, Your Honor. Thank you.
Jury instructions.
Are we doing that in here or in chambers?
We can do it in chambers, so I'm just going to limit it to just lawyers, so it's not too crowded in there.
What are we doing?
Just limiting we can meet in my office for finals, to talk about finals tomorrow. What? Yeah, no, 2 lawyers on each side.
Oh,
yeah.
okay.
No, I'll let you both come in. Yeah, I just.
Okay.
Yeah, okay.
The guys that speak to
You've got mail.
You are in the meeting now.
Well, good to know that we're in the meeting now. All this time I thought we were gone. All right, so we are going to portal over to Brian Kober one more time to catch the back end of what's going on over there, as the state is still going back and forth with the prosecution about what they should allow in the case and what they should not. I will tell you from the sounds of what we heard right now out of Michigan, they are nearly at the end of the case. They may be resting here soon. So we may get closing arguments as soon as tomorrow, which means we could have the verdict as soon as tomorrow. Crazy. But that's going to wrap up our day. We're going to portal over to Top Mark Media, my other channel, where Lois Cox and Red Pen are holding down the fort as moderators over there. Please be kind to them. Please keep your hands and feet inside the ride at all times. Hang on and enjoy the ride. I'll see if I can record those tonight, Josh. I'll check it out. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again tomorrow morning. It looks like 9 o'clock start. We may have closings. This jury might be able to start deliberating by tomorrow, say, I don't know, lunchtime-ish? It'd be cool. All right, be good to each other. Have a good one. We'll see you over on Brian Kober here in just a minute on Top Mark Media. Bye-bye.